I do just want to stress the special nature of genetic information. There has been a pushback against the idea of genetic exceptionalism, and I'm not so much advocating for the special treatment of genetic information in the sense that we treat it differently from any other form of information, but I do think, given certain special characteristics of this information, we do need to take a cautious approach to this and think more carefully about how we can better protect it. So, an individual's sequenced genomic data can actually serve as a unique identifier for them, but it can also serve to identify their family members. And although we've heard a lot of interesting work about anonymization and de-identification, and there used to be a lot of hype around using anonymization techniques in this context, there's growing recognition and a number of useful studies that have demonstrated that it's not really possible to de-identify genetic data in a way that would make it impossible to re-identify. And actually people with the right skill set have been able to re-identify individuals in quite significantly large genetic databases quite easily with access to very few variables. So you think about this as a new technology that commercializes DNA tests. Do we have a specific industry regulation? Well, generally we don't, so that means that data protection definitely has played a role, but also consumer protection, health, regulatory governance that we have that governs medical devices is also relevant. Human rights can also have a role to play. And while we have a lack of specific industry regulation, companies are often relying on their online contracts and their privacy policies as a means of industry self-governance or self-regulation. So I just want you to remember that all of us, or I would be very surprised if none of you in this room use email or any type of digital service, and so we have all encountered these terms and conditions in terms of service documents and privacy policies. And we need to remember that most of us, even as lawyers, will not read all of the things that we encounter online. And it's not really practical to do so because they are very lengthy, but it does mean that when you're dealing with a new type of service like this, in order for a consumer to actually understand all of their rights in this context, they would actually normally need to read several documents that are often quite long and may also contradict each other. And this is, Stuart, in his opening today, referenced the work of the Norwegian Consumer Council. And they've actually done some really useful studies on a number of things, including wearable technology and smart watches, and also smart toys. But also they have the App Fail campaign. There's a very useful report they've written on this, where they estimated that it would take the average smartphone contains 250,000 words of app terms and conditions and privacy policies. Most of you have a smartphone, I suspect. Most of you have probably not read all of that. And that is problematic if we're thinking about businesses actually complying with the GDPR and also complying with data protection law. And just to highlight this reality of the sheer time it would take for you to actually engage with these. This is actually quite an old study now, but at that time they estimated that it would take 201 hours a year for the average American consumer to read all of the privacy policies they engaged with online. That figure is likely to have increased now.